Article 22, arbitration and disciplinary action. Article 22 and 23 are often used in NAGE with disciplinary matters, and we'll be talking at length about both of these articles. Just cause is first mentioned in Article 22, and just cause is a legal term that union members share the right in having in disciplinary matters. It means basically that the Commonwealth needs to prove that there is a reason, a valid reason, just cause for causing disciplinary action to be taken place. There are no just cause protections when a member is on 6-month probationary period, when you're brand new and hired into the Commonwealth. Also, there's a probationary period after reemployment, and there is a probationary period at transfer to a new agency, but there are some limitations in that. So just cause is a very important right for all union members to have. The grievance form is set forth and defined under Article 22, so that bears a good look by any steward. And then the procedure is set forth in Article 22. And the procedure I just want to spend a little bit of time on in terms of how the steward and the union president or representative from NAGE needs to be in good communication. What we suggest is that first members discuss the matter, the problem that they're having at the agency with their union steward. Stewards then are in a position to be able to try to help out and try to resolve differences that are taking place in the workplace. If they're coming up with drawing a blank, certainly the steward should call their union president or their local representative to discuss the matter and see if we might be able to shed some light on how to resolve the differences. If they can't be resolved at the workplace on a normal relational basis, then some sort of involvement is going to be needed on the part of the union. And a strategy will be figured out between the representative or the union president and the steward, including the member. Grievances have 4 levels. Step 1 is handled at the agency, so that might already have taken place in part of the problem-solving process. Step 2 is also in the agency, but it's much more formal, and it's done, say, at a regional office. Step 3 takes the grievance outside of the agency and moves it to the realm of the Office of Employee Relations, where you have a hearing officer outside of the agency. So the theory is that it's more of an objective hearing on the merits of the case. And then step 4 is arbitration. Now, arbitration is outside of the administration. It's done with a judge arbitrator. Richard will be talking about that at some point. And it's much more formal. A member is represented by an attorney from NAGE, and the agency is represented by one of their attorneys from the agency. The point about arbitrations, and I'll get to this in the next article, is that arbitrations must be approved by the local executive board. They must be approved by a majority vote of the executive board. And let me stop here and turn things over to David Young to talk about arbitration and disciplinary action.
Okay. Article 22. Article 22 deals with just cause. Article 22 has one sentence that provides protections to NAGE members. It states that no employee who has served their probationary period of 6 months in the bargaining unit shall be disciplined without just cause. What is just cause? It is not defined in the collective bargaining agreement. What is progressive discipline? It is not defined in the collective bargaining agreement. This is my training manual that I used in my years as a management representative to educate managers on progressive discipline and just cause. I've trained managers, supervisors, and employees on progressive discipline because there are no secrets about this. There are standards for what is just cause and what is progressive discipline. It could be said that this manual brought progressive discipline and just cause to the managers of the Commonwealth over time. Problem was that when there was a change in administration or a manager turned over, they generally came in with no knowledge of progressive discipline and just cause, so it was an ongoing process to train managers.
We will be posting David's manual online as part of this presentation on Article 22 and 23.
Yeah, with all copyright protections.
With all copyright protections, absolutely. David Young, NAGE representative.
Before this training took place, management would often just store up their concerns about an employee's performance and behavior until they said, "I've had enough of this," and would fire them. That's not the way just cause and progressive discipline works. There are several basic principles to progressive discipline. Communication. Management must communicate their concerns to the employee. There shouldn't be a bomb dropping out of the sky on the employee. It's also a corrective action. It's not punishment. It's supposed to help the employee correct the problematic behaviors or performance. The employee has to be given an opportunity to improve. The employee should not be disciplined one step after another step after another step. They should be given an opportunity to improve before the various steps in progressive discipline. Documentation. I often say if it's not in the personnel file, it doesn't exist. Management must document their concerns and prove that they have made the employee aware of this documentation. There are no secret personnel files. The usual progression of discipline is a verbal warning, written warning, 1-day suspension, 3-day suspension, 5-day suspension, ultimately culminating in termination, which I always regarded as administrative capital punishment. You had to make your case. And that's an important point here. The burden of proof is on management to make the case in disciplinary actions. Whereas if you file a grievance regarding the language of the collective bargaining agreement, the burden is on the union to prove their case. Now, what is just cause? The standard I used as a manager, and which is in the manual, was as follows. This is my analysis that I would have with managers. Did the employer forewarn the employee of their deficiencies or behavior and of the possible consequences? Was the rule or order violated reasonable? This is sometimes part of the arbitration analysis, that you can't hold somebody to an arbitrary, unreasonable rule or order. Did the employer investigate the matter? This generally means that the employer should at a minimum meet with the employee before taking any disciplinary action and getting their side of the story. Was this investigation fair and objective? I remember one case I had where the manager sent a memo to Human Resources, please hold a hearing and fire this employee. The decision was already made before the hearing took place. Did the employer obtain sufficient evidence of the employee's so-called guilt, their performance deficiencies or behavior? Has management applied its rules, orders, and penalties even-handedly? You don't give somebody a written warning for a behavior or a performance issue, and then another employee gets terminated for it right out of the box. All employees should be treated equally. Was the degree of discipline reasonably related to the offense in the employee's record? Sometimes steps in progressive discipline are skipped. You may not give a written warning for an employee who has committed some sort of client abuse or falsified records. A stiffer penalty may be warranted. Now, I just want to touch briefly on the relationship between EPRS and discipline. As a manager, I would often see a disciplinary action undermined by EPRS. On the union side, I'm only too glad to see that. If the EPRS meets and the employee is disciplined, there's some disconnect. EPRS is not a disciplinary tool in and of itself, but it should be reflective. If somebody is disciplined for performance issues, there should be some mention of it in the EPRS that there are performance issues. Likewise, if an employee is not disciplined, there should not be mention of any performance difficulties in the EPRS. The two go hand in hand. In terms of the manual itself, I'm only too glad to hear that Greg is going to be posting this at some point, because I don't know if the managers are being trained at this time, because I've seen some disturbing trends. Employees are being disciplined without getting their side of the story. Employees are being suspended for a first offense without being put on notice by verbal or written warnings of their deficient performance or behavior. Employees are being given strange discipline, such as verbal written warnings, which are not verbal but written, and which are put in a secret personnel file. Discipline I've seen used as a punishment. The beatings will continue until your performance improves. It's supposed to be corrective and supportive, and management should be working with the employee to address these issues. And that's an important point that Greg raises. See if the matter can be resolved at the workplace before the employee gets in any deeper trouble with management. I've also seen employees with FMLA rights or ADA rights being disciplined, and management says their FMLA rights and ADA rights are irrelevant to the disciplinary action. The FMLA and ADA are often factors in an employee's performance or behavior at the workplace. Another disturbing trend is the not outright violation of Weingarten rights, but what I call a derivative violation of Weingarten rights. Weingarten rights provide that an employee has a right to union representation at any investigatory meeting where discipline is reasonably anticipated. And it's the responsibility of the employee to invoke this right. Management does not necessarily have to inform the employee of this right. However, management has been undermining Weingarten rights by calling an employee into the office with no prior notice of what the meeting is about, and they get questioned, and before they know it, they're disciplined. If you are called into an investigatory meeting, Weingarten rights should be invoked, but this does not apply to EPRS meetings. It does not apply to normal and regular supervision. Only when there's an investigatory meeting that might reasonably result in disciplinary action. Management will sometimes call an employee in and, as if it's a regular supervisory meeting, and say, "Tell me about yesterday," in a way not letting the employee on notice that this might be an investigatory meeting that might reasonably result in discipline. Employees should not be shy about invoking their Weingarten rights. I know some employees feel that if they invoke their Weingarten rights and get the union involved, they'll be in bigger trouble. I tell you this, they'll be in bigger trouble if they don't invoke their Weingarten rights. One more thing I want to touch on is don't let an employee waive their rights by not filing a grievance regarding discipline. I've seen written warnings that the employee does not rebut and put their rebuttal in the personnel file. I've seen employees who get a 3-day suspension, and when I look at the case, the employee got a 1-day suspension and never appealed it. Once disciplinary action is taken, if there is no grievance filed, no appeal taken, it becomes a concession on the record that the employee has not appealed it, and it can work to their dire disadvantage in any grievance or arbitration procedure. This is often the case where an employee has a medical or mental or substance abuse problem, or is on some medication that they don't want anybody to know about. They'll think the whole thing will just go away. It's important to get a piece of paper on file concerning their appeal of the disciplinary action. Okay.
Thank you very much, David. Richard?
Thank you. A couple of things I'd just like to touch on concerning the disciplinary process. And David and Greg have both done a very good job of giving a general summary of what the process is and how it works. First of all, with respect to progressive discipline, there are steps that the employer is supposed to take in imposing progressive discipline. As David pointed out, they start with a warning, then go to a short suspension, a medium suspension, a long suspension, and then a termination. Where the employers sometimes make a mistake is when they skip steps. So it's very important for us at when we're handling these cases to get a hold of the personnel file and find out what disciplinary actions the employee has had in the past, so we will know what the department has done with this employee, so we can prepare the case that is in front of us. A couple of things that are important to note with respect to previous disciplinary actions. One is that written warnings under the state contract age out of the file after 2.5 years, as long as there has been no disciplinary action taken in the interim. That's very important, because that means if somebody had a problem, say 3 years ago, that warning should be removed from the file, and it cannot be used against the employee more than 2.5 years later. I had an important case on this several years ago when the management tried to introduce an old written warning into a new disciplinary action, and they said, well, gee, the employee never asked to have his warning taken out of the file, so we can use it. Well, we took that particular point to an arbitrator who said, no, 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 no. The warning ages out after 2.5 years without any further action on the part of the employee or the union. So it's very important when you're handling a case and you have a copy of the personnel file, look at that written warning and figure out whether 2.5 years has gone by before any new disciplinary action is taken, and if so, that written warning must come out of the file and can't be used in any subsequent proceeding. Another point about written warnings. Under the contract, written warnings can be grieved to step 2 of the disciplinary process. Step 2 of the disciplinary process, as Greg pointed out, is within the agency. And we generally advise employees who have written warnings imposed on them to file a rebuttal that goes into the personnel file rather than file a grievance, because quite frankly, an employee is likely to lose a grievance on a written warning because it stays within the agency that imposed it. And an agency is not very likely to reverse itself on its decision to impose a written warning on a particular employee. So again, we generally advise employees to file a rebuttal, and the union staff will help you write a rebuttal if it's necessary to do so. But in that way, you're on record as having taken the time and marshaled the facts and the evidence to show why your written warning should not have been issued, and that if it ever comes up again down the road, there will be the record in the personnel file that you opposed the written warning in writing, and here's a copy of it that can be shown to the arbitrator. Now, suspensions work differently. Suspensions never age out of the file. They're there forever, unless it's reversed as the result of a settlement or an arbitrator's ruling. So as David pointed out, you don't want to ignore a suspension just because you're hoping it will go away or everybody will forget about it, or you don't want to rock the boat or something like that. Because that old suspension can come back to haunt you or the employee who was suspended. So it's very important to file a grievance and take it through the process, even though you might lose. But it's much better to try to get that suspension reversed or reduced down to a warning, so it's no longer on the record if anything else comes up in the future. Another point about certain forms of disciplinary action. Sometimes a department, instead of suspending an employee, or even in addition to suspending an employee, will also demote the employee Now, demotion is almost always a problem for the employer. The reason is because progressive discipline is supposed to be corrective. That is, the employer imposes successively more stringent discipline, starting from a warning, then the 1-day suspension, the 3-day suspension, the 5-day suspension, in the hopes that the employee will improve his or her behavior or performance in the workplace. And it's supposed to be, again, it's corrective. However, a demotion is permanent because as a result of a demotion, an employee may go down 2 or 3 pay grades and lose a significant amount of salary forever. And arbitrators almost always view that salary reduction as a punitive and not a corrective measure. And that's subject to reversal by an arbitrator. I've settled a couple of cases when an employee was demoted, and I've been able to go to the other side. Of course, by the time I get into the case, it's always represented by counsel, and I can say, look, we should settle this matter because you demoted employee X, or your agency demoted employee X, and arbitrators can look at that as punitive. And in a couple of instances, I've been successful in convincing the agency to reverse itself and put the employee back to whatever position he or she was in at the time of the demotion, sometimes with complete back pay and sometimes not. But it's a very important distinction to make, that demotions are almost always going to be viewed as punitive and not corrective. Another point with respect to progressive discipline is some things, as David pointed out, in some instances, the employer is supposed to have informed the employee of the expectations that the employer has in a particular situation, and to let the employee know up front what the expectations are so there aren't any surprises. And the employee can't say, gee, I didn't know I was supposed to do that, or I didn't know I wasn't supposed to do that. There are exceptions to that. For example, you can't punch out your supervisor and say, oh, it's only the first time I punched out my supervisor, so you can't fire me for that. Guess what? They can't. The other thing they can fire you for the first time is that nice laptop that you saw on somebody's desk, you can't steal it. That will get you terminated first time. So physical violence in the workplace, theft in the workplace, things of that serious nature are not covered by progressive discipline. So keep that in mind. And finally, with respect to arbitration and the grievance process in general, it's very important to meet deadlines. You need to meet deadlines not only to file the grievance in the first instance on a disciplinary matter, you also need to meet deadlines for moving the case through the process. The contract is very specific about how much time you have to file the grievance initially, and also to move the case into the process. Say you get a decision at step 2, the denial. Well, you have a set period of time to move the case to step 3. You need to be familiar with those timelines and you need to meet them. And finally, with respect to arbitration, as Greg has indicated, when a case gets to arbitration in this union, the grievant is represented by an attorney, one of the members of the NAGE legal staff. And the attorney will be assigned to the case, will reach out to the grievant a certain period of time before the arbitration, and will want to meet with the grievant to go over the case, find out what the evidence is, obtain documents, find out if there are any potential witnesses, and prepare the grievant and any potential witnesses for testimony. Arbitration is a more formal process than the grievance hearings that you might have been to in the past. Arbitration occurs in a conference room, essentially. Each side is represented by an attorney. There is an arbitrator who is selected off a list that's maintained by the union and the Commonwealth. We select arbitrators whom we know and we feel will give our members a fair shake. And it's a somewhat formal process. I don't need to go into all the details of how that process works here, but suffice it to say that the NAGE attorney will go over everything with you, with the grievant, with any potential witnesses in preparation for the arbitration, so you will know what to expect. It's very important to listen to the attorney when he or she is going over the process with you, so you will know what to expect and how the arbitration hearings will unfold. And that's all I have.
Well, thank you both very much.